Good afternoon. Thanks everyone for joining. Welcome. I'm Arthur Krantz. I'm a PERB board member. With me is Eric Koo, who is PERB's Chief Administrative Law Judge, and Janet Corey-Summer, who is Kaltara's CEO. We are excited to be celebrating PERB's 50th anniversary this year, as many of you know. As part of that, we have been doing monthly trainings. We also have 4 bigger events, one of which was in April. Besides today, we have our biggest event scheduled for September 19th in Berkeley. It's a Saturday. You can register on our website. And the last big event will be at our public meeting in Glendale in October. All of these you can see on our website. Look for PERB 50 Forward. That's the tab. And if you've missed any of the ones that have happened so far this year, you can watch them there. Today, we are going to be looking at evolving approaches to public sector labor law research and analysis, which is why we've called it From Print to Pixels. And that is part of our theme for our 50th anniversary, which is looking at our past, our present, and our future. I'm going to turn it over in a moment to Eric Koo to start us off, but first, a few standard disclaimers that we always give. The views expressed in this presentation are those of the presenters. They are not PERB's official position on any matter. The content is for general informational purposes only. It is not legal advice. Some statutes that PERB administers have unique characteristics that may differ from the general principles we discuss, so please refer to the specific statutes, regulations, presidential decisions, and other authorities. And you can send questions about this material or our processes to perbquestions@perb.ca.gov. And with that, I will turn it all over to Eric.
Okay, yes, thank you, Ari. Let's start with the introduction about what we're going to talk about today. We'll begin with discussing some legal research tools that are available when doing research for matters before PERB. Next, we will get into how artificial intelligence might affect your research projects. And finally, we have a hypothetical situation planned, and we'll talk about how to actually apply some of the tools we're talking about, including AI, but including some other more traditional methods, and how that might work in a real-world scenario. Okay, starting with legal research tools. We have here on this slide what we're calling legacy research tools. Some of you who are the older practitioners, people who have been in the game for 15 or more years, might remember the California Public Employee Relations, or CPER, pocket guides. The CPER also did monthly newsletters. However, these are not being updated anymore, so I think the CPER pocket guide stopped being updated in 2020, and they stopped publishing the newsletters in 2013. So if you are still looking at those guides, do be careful. There have been quite a few developments in the law since then. And in case you're wondering, I'm not making fun of anybody. All of these photos on the slide are actually from my own library. So I'm one of the old-timers. Moving on, we have the Public Employee Reporter for California, sometimes called the PERC Journal. That is a independent journal that talks about, or that compiles all board decisions, ALJ decisions, and related court decisions on public sector matters. That is still being updated and published by PERC. However, whereas that used to be cited more often in sort of legal writings, the vastly more common process now is to simply cite to the board's decisions as they're listed on the decisions themselves. Finally, on this page, we have PERB's representation checklists. PERB used to put out these sort of lists of questions and issues that people might encounter, help them navigate the representation petition process. We took those off the website because they had not been updated for quite a while. And so if you still have those archived somewhere, do be careful. We'll talk a little bit later about some other tools that you might use instead of these as we get further into the presentation. Okay, so Another good resource that you might consider using is a lot of law firms that practice in the area of labor relations. They put out some pretty good materials. They have blogs, webinars, other trainings, put out legal updates. A lot of those materials are pretty good and pretty thorough, especially for those of you who are newer to the practice. But do be careful if you are looking at law firm material. A lot of law firms tend to be organized by their clientele, either labor or management, and so with that, they're largely speaking to their clientele, so there will be a particular perspective sometimes, so just be aware of that if you're looking at law firm materials. The California Lawyers Association Labor and Employment Law section also puts out some really excellent material. They put out a newsletter with legal updates, developments in the case law that I for one look at pretty regularly. There are also trainings, seminars, conferences and things like that. There are other associations out there, both bar associations and labor relations associations that put out other kinds of materials, including conferences, trainings and things like that as well. Moving on. This slide shows some treatises and practice guides, and now we're really getting into the material that at least I look at on a pretty regular basis. I would say I am looking at these two sources, the California Public Sector Labor Relations book and the Developing Labor Law book, pretty much every week. Public sector labor relations, as its name implies, focuses on public sector work. There's quite a bit of material about PERB's position, about PERB decisions in that source. The Developing Labor Law focuses on the private sector. Now you might sometimes hear people calling these books Zerger for the California book and Higgins for the Developing Labor Law after former editors. So if you hear that out in the field, that's what they mean. And we're going to, the Developing Labor Law used to be like a very important source because a lot of earlier PERB decisions did rely quite a bit on the private sector. I would say nowadays that influence is not quite as pronounced as it used to be because as PERB's own body of case law has grown and not always followed the private sector. So do keep that in mind. We will be looking a little bit closer at public sector labor relations in this presentation, so stay tuned for that. Okay, moving on to online legal search engines. So the lawyers in the audience will probably be familiar with Westlaw and Lexis. Both of those are subscription-based legal authority search engines. You can use those to search, to do some pretty complex searches for legal authority. Both Lexis and Westlaw do have specific databases for public sector labor relations, so that will capture PERB decisions and related material. But as I said, it does come at a cost. It's not free, and so if you are not part of if you don't have a subscription, some law libraries will have access to a Westlaw or a Lexis license. You could access it that way. If you don't, then there are other free resources out there, including Google Scholar Case Law. FindLaw will help you to find published court decisions. I don't believe those free sources will have PERB decisions on them, but as we'll get into in just a little bit, PERB's own website, we publish all of our precedential board decisions, and so that is going to be a great way to find PERB decisions. Now, I think if you are using Lexis or Westlaw, there are some pretty notable advantages and disadvantages that you should be aware of. I think the biggest advantage is just the sophistication of the search engine. You can do some pretty complex searches and narrow it down to into sort of just on public sector decisions. For example, if you wanted to know what the PERB board has said about whether an employer installing GPS devices on their own equipment is a matter within the scope of representation, you can do a search for that specific topic and yield some pretty good results. Some disadvantages to think about, though, are that for the most part, the search results are going to be a combined set of precedential decisions, non-precedential decisions, and ALJ proposed decisions, and only the precedential decisions are really citable as authority in your legal briefs. That said, I still like looking at other kinds of decisions. Sometimes a non-precedential decision or an ALJ decision will give you some pretty good insight into how to frame an issue or how to look at an issue, even if I ultimately only end up citing to a precedential decision. In addition to that, Lexis and Westlaw, they don't have the page numbers of board decisions. It's just the way that they sort of generate the board decisions. So if you want to make pinpoint cites in, say, a legal filing or a brief, you will not be able to get those individual page number citations from a Westlaw or a Lexis source. And finally, another thing to think about is Lexis and Westlaw both have a tool for assessing subsequent history in court decisions. The lawyers in the room call that shepherdizing. But the shepherdizing tool does not work on PERB decisions. So you won't get any sort of easy access to subsequent history if you're doing a search specifically for PERB decisions. We'll get into this a little bit later. Our own website has some resources that can help in that way. And in addition to that, one way to sort of get around that issue is if you're doing a Lexis or Westlaw search and you find a decision on point, you want to find out if it is still current law. You run a search for that decision with that decision number, or then you will find subsequent references to that and see if any later cases have cited to it or has any kind of subsequent treatment. All right, so we're going to move on to our website. We have quite a bit of material on our website to help both new practitioners and seasoned practitioners. And this slide here is a kind of an overview of some of the things we're going to talk about. For people that are newer to PERB, we have several different kinds of unfair practice charge guides or UPC guides. There's a how-to that sort of walks you through each step of the process. There is a description of each step of the way, and that will really help people that are unfamiliar with PERB or not sure what stage of the process they're in, sort of navigate through the system. We also have a decisions page, and there's kind of separated into three different ways to access our decisions. First of all, there's the recent board decisions. That's just a straight list of the 20 most recent board decisions, and you can look at them that way. We have a topic index, which we will discuss in more depth later on today. But that gives you a chance to browse or search for a specific subject matter and then find cases on that subject. And finally, there's just a comprehensive list of all the board decisions, starting with the most recent and going backward in time. And we'll look at that a little bit later as well. In addition to decisions, we have law and regulations pages, which gives you the full list and statutory text of all the statutes that PERB enforces. Similarly, we have a page for our regulations, which you can access either by chapter, if you know the chapter or subject of your regulation, or through a full and comprehensive set. There's also rulemaking, which are proposed regulations that you can look at and see what kind of regulations the board is considering. In addition to those sources, there's a frequently asked questions page, or FAQ, that talks about common questions that we encounter from the public and answers to them. Oftentimes, the FAQ and even the how-to guides will link users to a PERB glossary of common labor relations terms, other sources that can give people guidance on how to navigate the process, or what a particular section of board decision or statute what it means in sort of labor law parlance. More recently, PERB has put out a series of training videos concerning the UPC and the State Mediation and Conciliation Services processes. It's a really good way to get introduced to the different services PERB provides, how to navigate through them, and really how to use the agency effectively. Okay, so we are, this is the PERB index. It is a decision index of, well, like I said, it's the list of all PERB decisions in numerical order, starting with the most recent. And you can see from the list that there is the decision number, the decision name, case number. There is the PERC number, that's the journal that I referenced earlier. And some of the links, some of the sources, some of the cases will also refer to a PDF. And that PDF, for example, on decision 3006, that PDF is actually a hyperlink. It will take you to the full text of the board's decision. And unlike with Westlaw and Lexis, that does give you the full the full board decision with individual page numbers. The decision number, for example, 3006M, is also a hyperlink that takes you to our headnotes page, and we'll talk about headnotes in just a little bit. But basically, it's a summary of different topics covered in that decision. Our decision list also has some, not all, subsequent history information. For example, this screenshot shows decision number 3002 as a judicial appeal pending indicator. That means that that particular decision is currently subject to an appeal. There are other kinds of subsequent history that we try to keep up to date on the website, such as if something was overturned or modified by another decision, that would be indicated in the same way.
If I could jump in there, I know we're already a little behind, but I'll try and keep it brief. Yeah, what Eric's saying is really important. It's something we started doing about 7 years ago. PERB had not done it in the past. We mark cases, decisions when they are overruled, partially overruled, vacated, modified, clarified. Those are the general ones. You'll see that in two different places. You'll see that across the top of page 1 of the decision. You'll also see that in the decision bank that we're looking at right now. There'll be a warning. It could say judicial appeal pending, which of course is a temporary status, just warning you, you can cite this decision, but the Court of Appeal is looking at it right now. Or it could say partially overruled, would be very common. And then it's up to you to figure out, well, in what way was it partially overruled? Neither the top of page 1 of the decision nor the decision bank will tell you, but, and we'll be getting to this a little bit more in a minute, if you click on the left side where it says, for instance, decision 3002E, that takes you to the headnotes page, which we will be looking at, and the headnotes page will tell you which of the headnotes are still good law, which have been overruled, and in what way.
And I was just going to add one other thing. The only decisions that you can get through the PDF are precedential decisions. The non-precedential decisions aren't immediately available on PERB's website, but if you really want to see them, you can ask PERB for them. And I think it's the PERB questions is the link. The website tells you how to request them.
I should have said, just like on Lexis and Westlaw, they have Shepard's and they have KeyCite, and you can't 100% trust it, right? It says something, and that's a good flag, a good caution, and then you gotta go read the decision and see if KeyCite is right, see if Shepard's is right. Same for what we have. We might have missed things. It might not be. You might see, oh, this headnote says it's still good law or not. You need to read the decision to be sure.
But as someone who's been practicing for a while in this area, I want to thank you for doing that because it's hugely helpful.
Yes, thank you for making those points. As to the point that Ari made, yeah, I mean, one of the reasons why we put our most recent decisions first is so that, you know, we really want to encourage people to be citing to the most recent authority that we're doing. And as we look at a headnotes page, we're going to see that as well. And you know, that is another sort of defense against citing a case that may have been modified, overruled by subsequent cases. If you're looking at the most recent authority on a particular subject, you're that much more likely to be citing something current. And as to what Janet said, yes, you can only see the PDF, the full text of the precedential board decisions on the decision bank. You can still see the headnotes though, so you can see the topics that a non-precedential decision has covered, and you can sort of get a sense of the non-precedential decision, what they discussed that way. Okay, moving on. This is the PERB topic index. This is a list of different labor relations subjects that people can browse through to help with their research. Each topic will typically have subtopics. So in this case, we see a screenshot of the scope of representation topic, followed by a list of many subtopics for that issue. And if we go, I'm going to go to the next slide. The next slide will show, this is what, if you click on a subtopic, in this case job duties, this is what it's going to show you, a list of current precedential decisions on that subtopic, brief summary of what that decision has said about the subtopic, and then once again, starting with the most recent, so that's how you really want to do your research. And you'll see here the text that says full text. That is a link to the full text of the board decision, once again, with page numbers if you want to do your pinpoint sites. And there's also an all topics text, which is also a link. And let's look at what happens when you click on that. So if you click on that all topics, it takes you to the headnotes page. And what that does, it is a description of all the different legal discussions or analysis that happened in that particular decision, and a brief summary of each of those topics. And we'll see, as Ari had mentioned earlier, in each of these little notes, you'll see some subsequent history information. For example, overruled on other grounds in this other decision, PERB decision number 2409. So the way to interpret that is, yes, this decision has had some negative subsequent history, but not on the particular topics that are on this page.
And I would just note, all three of these, you would hope, if we did our job right, the principles in these headnotes are still good law, because the case was overruled on other grounds. We don't have it up here, but if this principle shown in that headnote had been overruled, it would say simply overruled by, and then the case name, such as Sonoma County Superior Court, where the board ruled, and then it would tell you our best estimate of what the issue was that was overruled. That's the only way that you're going to have a hint as to what may have been overruled. Of course, again, please read the case to be sure.
Okay. So the PERB statutes page is just like what I said earlier. It's a full list of all the statutes that are under PERB's jurisdiction. The names of the statutes are also hyperlinks, and those links will take you to the full text of that statute directly from the California Legislative Information website. So the text that you'll find there is as current as what the legislature puts out on its own materials. Moving on. This is the PERB regulations page. Like the statutes page, you can get the full list and full text of all PERB statutes. It is organized by chapter number. If you know the chapter of your regulation, you can look it up that way. My own preferred method is to go to the section titled PDF of Regulations. From there, there's a link to a single PDF of all of PERB's regulations. And the reason why I like that is that does have internal hyperlinks to particular sections from the table of contents. It's also searchable, so if you want to search, for example, continuance, motion, extension, you can quickly get to that part of the PDF just using the search function. Now, we do have limited past versions of our regulations available. It's not a comprehensive historical archive, but in case you find a decision that cited an older version of a regulation, you can get some of that information directly from our website. We'll go through these next pages fairly quickly. We have, as I said earlier, we put together a list of training videos for different parts of our process. You can get them right from our website. It's a really good way to get introduced to our process and get perspective directly from the board agents who are practicing. You can see there are videos on investigating UPCs, informal conferences, the pre-hearing process, and the hearing process itself. State Mediation and Conciliation Services also puts out a good set of training videos about the services it provides and how to access them. In addition to that, we have PERB 50 Forward events. Ari mentioned that in his opening remarks. We're putting out a series of content about our process and how to use it. There are some good materials in there, including panels like this one. And so do go to the 50 Forward page. You can register for many of these events, including our September conference. So do check out the 50 Forward page and register to any events that you're interested in. Other resources I'll go through quickly. We have fact-finding reports on our website, the Public Utilities Code, Transit District Representation Decisions, recent news, and the one I really want to emphasize is our email distribution list. If you're not on our mailing list already, it's really a good idea to sign up. Not only will you get recent news about our decisions, about PERB, but you'll also get provided with new decisions coming out from the board as they're issued.
All right, I'm going to take us through this next part. You can see it on the screen, artificial intelligence. As part of considering PERB's past, its present, and its future, we are going to be talking a little bit about AI. But first, I need to add to the disclaimers we had at the beginning. None of the three of us are experts in AI, so take what we say with a grain of salt. We will share with you what we're seeing in terms of AI, and we did, over the last month or so, do a little bit of testing of free and paid platforms, just so we don't look entirely foolish. The first slide I'm going to get to in a moment is about mostly about AI use by unrepresented parties, although some of the principles are also going to relate to AI use by professionals. Before I go to that slide, just one thing that's not shown there, that's no secret that PERB, like other agencies and like courts, has been flooded with filings that are produced by AI. As a result, we get more filings, especially by unrepresented parties, and more cases, more types of filings within those cases, and it does impact our workload. That is not part of today's panel, so we're not going to probably talk about it again. I just thought, since it's well known, that now you know it too. Okay, AI use by unrepresented parties. The first point is that AI can promote access to justice by helping unrepresented parties know what the law is. Previously, we might have gotten a charge that is talking about a statute that we do not enforce, and it would pretty quickly be dismissed. Now, the AI could do a pretty good job of telling the party, well, this is the statute PERB enforces, these are the standards, these are how your facts might fit into those standards, an improvement, right? But going to the second point, this leads me to, and I'm going to be asking Eric on behalf of Division of Administrative Law, is this real access to justice, or to what extent is it? Because it might help an unrepresented party get a complaint issued. That's not winning the case. They still have to prove their case. So Eric, is AI real or fake as access to justice? Is it really helping?
Well, you might not be surprised to hear it's a little bit of a mixed bag. I think it's a little early to tell. This is still very much an emerging issue for us. But I do see the points that, in practice, the same points that you're raising. We do see a little bit more sophistication from parties. They're able to understand what it means to file and respond to motions a little bit better. They understand that they have rights to get subpoenas. We've seen an increase in parties seeking reasonable accommodations. So I do think that there is some better understanding of what it means to access PERB and how to navigate through the system. We also do see maybe slightly better know-how about what statutes and rights we enforce and what we don't. But the flip side of it is very much what you said. We've seen filings where they look like a sophisticated piece and a good articulation of a request, But when we bring the party in for a pre-hearing conference, we bring them into the formal hearing, the substance isn't always there. They're not always even understanding the merits of their own filings. And so it's really difficult to have a reasoned discussion along those lines. And so you can see a scenario where, somebody is able to, as you say, just inundate a case with case filings, and you might feel like that party might feel like they're achieving something just by the sheer number of what they're doing, but are they really advancing their case in a good way? Not always. So it is quite interesting.
With that, we also very much need to note some of the drawbacks and risks involved. Hallucinations comes first and foremost. It's well known, has been reported in the press, and we've seen it at PERB. AI can cause you to cite cases and decisions that do not exist, which is a big problem. It can also cause you to cite a case that does exist, but it will make up a quote. It'll even assign that quote a page number that doesn't exist, maybe a page number that's not even in that decision at all. Or more subtly, it can just change, not a quote, and it's a case that exists, it's not a quote, but it can change the holding of the case. All very big risks. Also, there is a potential lack of confidentiality. I don't think we're going to spend a lot of time on it, but we will return to it when we talk about AI used by professionals. If you're an unrepresented party for now, or if you put something into a free program, ChatGPT, etc., it's out there, and you might want to think about that a little bit, especially if it's sensitive information. And that leads me to the next point, which is consider the platform's defaults and policies. There could be a policy, especially if it's a paid platform, if it's Lexis plus AI or something that may promise you that it's a closed system and that they're not putting your information out there. Maybe on ChatGPT or your program of choice, maybe there's a slider bar that says it will not be used for training purposes, whatever that may mean. That's obviously, if you're an unrepresented party, that's for you to decide for yourself, but you should be aware of it, whether you trust that. And the defaults, I think what we mean here is in the same place where there may be a slider bar, like don't use my what I put in for training. There's also defaults about how ChatGPT or another Claude, etc., treats my queries. It can be very warm and effusive and enthusiastic, but you can change it to neutral and professional, and you can even input stuff such as don't affirm what I'm saying, or if you do, first tell me the flaws. Be skeptical about everything I'm saying. Be skeptical about what you're saying before you say anything. Tell me how certain you are. Those are all things that custom prompts you can put in could be helpful. Most importantly, do not file, and this goes to Eric's point, do not file anything you did not read, that you do not understand, or that you did not double check. You're really doing yourself a disservice. Okay, many of these same points are also important for professionals, but there are some other points that we want to emphasize for professionals. First, your organization probably has already or should soon have an AI policy, and you should comply with it. Janet, your Calpados members probably are working on these policies furiously.
Right, they are, and they cover the gamut of issues, including certainly confidentiality issues. Some policies require you to identify that you've used AI in whatever your work product is. Some require that you report your use of AI and exactly how you've used it, because agencies are trying to keep track of that, and a variety of other things. So your point about complying, knowing your policy and whether there is an absolute prohibition on using AI, and then how you can use it and complying with that. So, and those are going to keep evolving over time.
As to the second point, we are not neuroscientists, but we would just say there's been a lot of writing about how AI use can hinder your development of expertise, or maybe you're already quite expert. It could even hinder your writing and thinking skills, or speed up the rate at which they're atrophying or something of that sort. So what you should do about that, I don't know, but perhaps, and we'll be getting to this a little bit, if you do find that you're using AI to save time, treat it at best hopefully like a colleague who you would talk to down the hall, or who would review your ideas. Try to do the drafting and thinking yourself, because drafting is thinking, and use it on the side at most. AI hallucinations we have already talked about, but if you are a professional, it is even more of a cataclysmic potential risk. Your reputation, indeed your bar license or your career could be at stake. Don't discount the risk of a major fiasco. And we have seen that at PERB. We have seen attorneys cite to fake cases. Going to this next slide, PERB is concerned enough about this. We have a banner that goes across every page of our webpage, I believe, of our website, I believe. It's a notice regarding use of general artificial intelligence, and it says for more information, please see a decision called Atwater Elementary Teachers Association. In that case, an unrepresented party repeatedly cited to non-existent PERB decisions, and the board addressed that issue in its decision and warned parties and attorneys about potential negative consequences from AI hallucinations. What are those consequences? Well, the PERB board noted some, but not all of them. Among other risks, your filing can be rejected, your case can be dismissed, you could face monetary sanctions, and an attorney citing fabricated decisions may be reported to the state bar. There could be other issues.
And just briefly, speaking of attorneys, the state bar last month approved a report, some recommendations about the use of AI. So there's a lot of things to look at. There's also legislation pending, so keep your eye on this if you're going to be using AI.
Yes, and I'll just jump in to say, these aren't theoretical risks. This is happening at the agency, and we have rejected filings based on hallucinated material in them. So just please be careful.
With all that said, we know that there are advocates out there and unrepresented parties using AI. We're going to try and talk about maybe some of its other uses real quickly before I turn things over to Janet. First, we did some testing. What did we find? We put in a bunch of different kinds of hypotheticals and prompts and instructions into different platforms. We found variable results, especially the sources that when we asked AI to reveal its sources, it might be relying on some of those blog posts that Eric was mentioning. Might be great, might not. It might be telling you about decisions that it has not read. It just read about what the blog post had to say. It might be giving you, either relying on or giving you decisions that are not the newest ones, and therefore you should be worried about them. They might not be the ones that are most on point. They might have been overruled. I got a response, and then since I knew it was overruled, I told the AI, "Isn't that overruled?" It said, "Yes, it was," but it had not told me that to begin with, so that's concerning. Given all those problems, the answers that we're giving were not terrible. Actually, it was managing to draw from these not the best sources always, not the ones you would be wanting to cite in your brief, but it's outcomes, and we'll look at a couple of them in a minute. Some of them were stronger than others, so beware. Other potential uses, these next final two slides are just things you should be doing as an advocate and should have always been doing. First, maybe AI can help, maybe not. If you know only your side of the case, you know little of that, is a famous quote. Maybe the AI can help you brainstorm your opponent's arguments and stress test your theory. That's something you should always be doing. Same caveats apply though. Just as it can make errors in telling you about your theory, it can make errors in telling you about your opponents, but it'll do it fast at least. Okay. If your AI, yes, only as your organization's policy permits, and consider the confidentiality issues, and those go hand in hand. Your organization will tell you what you can, hopefully what you can and cannot put into AI. Maybe if it's a closed system like Lexis plus AI, they let you put in more. I don't know. Maybe same thing. Maybe the AI can generate practice cross-exam questions to run through with your witnesses, but all the same caveats might apply. One final potential use for AI is writing, again, these are things you should have been doing all along, and we hope advocates still have time to do, even in today's fast-paced environment. Sit down and write, and revise, then revise again, and finally revise. Hopefully you are revising your own documents. Hopefully your colleagues, human colleagues, are revising them. But as noted here, your colleague may not want to read your brief for the second, third, or fourth time. They just have their own cases to work on. You could, if your organization lets you could run parts of it through AI. If you are, I would say, if you're an expert, AI is probably going to tell you 10 things, and 9 of them you're going to have thought of, addressed. You're going to realize the AI is wrong, but the AI is probably going to instantly tell you 10 things, and maybe one of them, just like your colleague may tell you 5 things, and 4 of them you thought of. There'll probably be something you hadn't thought of. So maybe. If you're not a professional and you're new in this area, then there's going to be a higher reward ratio for the number of things AI is going to say, is my guess. AI, if you're allowed to input what you have into AI, it will help you with writing, much like Grammarly or anything, help you with passive voice, help you with clarity. But if you find AI useful for any of these things, please keep in mind all the caveats we've been talking about.
All right, so we're going to move on and talk about a hypothetical research project. But before I do that, I think one use for AI that's really helpful is if you are really totally lost and you don't know where to start with an issue, just like you might have back in the day just Googled the question or Googled the issue, AI can help you to get started. So I think that might be something that we all think is worth using, again, as long as your organization's policies allow you to do that. So we thought it would be helpful to take a hypothetical research project and just try using some of these sources and demonstrate for you how some of the sources that we've talked about work in the real world. So the scenario that we're using in our hypothetical is this. After a heated grievance meeting in a California city, a union steward says to the steward's supervisor, "If that's how you want to play things, you'd better watch your back." And the supervisor perceived this statement as a threat and it wants to discipline the steward for making a threatening statement. The issue is if the city decides to impose discipline against the union steward, is the union or the steward going to have viable claims against the HR, against the city, and are they likely to prevail? So let's just see how we might address this using various sources. So for me, if I've got an issue that is new to me, and this was an interesting exercise to say, how do you do research? I have to say that when we first talked about this, I thought, how do you do legal research? It's like, how do you walk? How do you read? It's hard to remember how you do these things. But when I don't know where to start, I will often go to the California Public Sector Labor Relations Practice Guide that Eric talked about earlier. And using that guide, again, particularly if I don't know what doctrines apply, I'll probably start with the table of contents. There are 22 chapters, I think, and I'll just sort of scan down and look at the chapters and think what may or may not apply here, and see where I want to dive in. And with all of these issues, it's important to remember that oftentimes any issue that you're looking at may cover more than just one concept. So you want to be careful not to, just because you hit on something that's relevant, don't stop there. Make sure that you keep digging and see if there are other pieces to the puzzle. So the index for the California Public Sector Labor Relations Practice Guide, I will use. Sometimes it'll get me right where I want to go, but to be frank about it, the index needs a little help. So if you don't find something in the index, don't give up. Go back to the table of contents and see if you can find it, because it does cover a broad set of areas. And then finally, if you've got access to the book in its electronic form, you can search. And that's actually probably the most effective way to use the book today. If you're a Lexis user, you can access the book through Lexis, depending on your coverage.
And if you're not a Lexis user and you have your own subscription, you get a choice of paper or electronic. Maybe if you're in a 2-person office, one of you does paper, one does electronic. But yeah, if you can only do one, choose electronic for sure.
And it is, it's not an inexpensive item to have, but if this is the kind of work you do, it's probably something you want to have on your shelf. So we're going to just dig in and thinking about our hypothetical, we're going to, if I scan through the table of contents, I pretty quickly realize that probably chapter 13 is the place I want to be, talking about protected employee rights and activities under the public sector statutes. And it's got a series of subsections that I will recognize that I want to look through. And protected activity, part B, looks to be the most likely So I'll drill down into that, and it's not necessarily obvious from the more detailed table of contents exactly where I want to go, but participation in concerted activities looks like where I want to take a look. And bingo, you can see here in the first section, section 1304, we've got the practice guide tells us that PERB has followed First Amendment principles to distinguish a true threat, one in which listeners would reasonably believe they might be subjected to physical violence, from bluster, figurative language, and other speech that doesn't, in context, constitute an actual threat. So I realize I need to be thinking through whether that "you better watch your back" is reasonably a threat or not. It goes on to explain that employee speech related to employer-employee relations won't lose its statutory protection just because it's intemperate, disparaging, inaccurate, or engenders ill feelings and strong responses, unless the employer meets its burden to prove that the speech was maliciously dishonest or so insubordinate or flagrant as to create a substantial disruption or serious risk thereof. So I see that we've got this test. That's how I'm going to decide whether "you better watch your back" was big enough to be unprotected. And then the practice guide goes on to explain a little history and context, and here it says PERB no longer applies an imprecise standard for determining whether speech loses its protection that was originally set forth in the Rancho Santiago case, and instead PERB applies one or both of two tests depending on the nature of the respondent's arguments. So what's nice about the practice guide is it gives you explanations and puts things in context and tells you about how the law has evolved. So that's obviously useful. So another way to go, another place you might go, is to the topic index that Eric talked about at the beginning of the hour. And I think that for an issue like this, if I were researching it, I would probably just scroll through the browse by topic index. There are a variety of ways you can, and we'll get to some of the other ones, but one way is just to scroll through. And it's a pretty long scroll, but there are headings that will help you, so you don't have to read. You can get through it pretty quickly and recognize where the areas that might be useful to you, and where you can find potentially relevant notes that are going to identify the cases that are relevant. And again, keep in mind that there may be a variety of areas that cover your particular topic. So I want you to not stop just because you think you've got something on point. So an example here in the topic index, I think the first thing you'd see as relevant is unfair practice issues, protected activities. There are a couple of subtopics. There's a whole list of protected activities. Grievances might be relevant because this is a grievance meeting, but the one at the bottom of the list called speech is the one that is more relevant. And if you pull up the notes for this speech subtopic in the topic index, you'll get a number of the cases with the head notes and a brief explanation, and you can fairly quickly see whether the case that's listed is going to be relevant to you. So ERA allows employee and union speech on protected topics to be impulsive, intemperate, disparaging, and so on. And you can see that the Hacienda La Puente case is going to be useful from 2024, also the Sunline Transit Agency case from the same year. And as Eric said, these are always going to be listed newest case to oldest, which reiterate how important it is to read the most recent cases because the law has been evolving.
Yeah.
And you can also, this is just another thing you might look to, or are there any defenses you might look to, and so you can look at that section of the index. And again, the same Hacienda La Puente and the Mount San Jacinto Community College District cases come up with some relevant head notes that let you know that you want to dig into these cases and read the full cases about them.
And so this might be a good place to kind of get a sense. So if you're looking at the California public sector labor relations, I think that's a really good source to use you're not really sure what it is you're digging for and you need a little bit more narrative, a little bit more explanation on how this fits together, that's a really good source to use for that. If you know what you're looking for, like, okay, I know this is a speech issue, I just need some current case law on it, let me find that in the PERB topic index. That's a way that these two sources interplay depending on what your particular needs are. I just wanted to point that out.
And so you can use the search, as you just said, Eric. This search function isn't as sophisticated if you're a Lexis or a Westlaw user. It's not, you can't build that kind of a search. But you can do some basic searches, and if you want to add anything about the way to do a more sophisticated search on PERB's website.
Sure, yes. PERB's website is not great for searching. Usually I would go to Westlaw because I have access to it. If you do not have access to Westlaw, within the topic index you can do very limited searching, or you can search the entire website using Google's functions, and that is a little more sophisticated. It will draw from the entire website. Probably though, if you are searching legal terms, it's mainly going to be drawing from the decision bank, and the headnotes in the topic index, which is probably what you want to be searching. So that's what you'd want to use the overall search function at the top, which is, I believe, it's integrated in the website, but it's brought to you by Google, I believe.
Okay. So if you do a speech search, you're going to get to the headnotes that are relevant here. Again, labor disputes can engender ill feelings and strong responses, and employees have a right to be, there's leeway for impulsive and intemperate behavior. So same set of issues, and you will see on this particular description, PERB conducts a fact-intensive inquiry that considers all the relevant circumstances, including but not limited to the place of the discussion, the subject matter, the nature of what occurred, and the extent to which the speech can fairly be said to have been provoked by the employer. So those headnotes give you all of that information, and that tells you this is the case that I want to look at. And the slides don't identify it, but this comes from the Regents of the University of California, a Los Angeles case from February of this year. It's the first one that comes up because it's the most recent. One of the things that I'll often do, if I think this case is relevant and it's that recent, I can just skim through the recent decisions and see if there's anything more recent. Otherwise, I might, I can identify this as the most recent case on an issue. All right, and here I just highlighted an example. We talked before about the head notes and the decision, the subsequent history information, and here's an example of one that's just a little more detailed. So the Rancho Santiago Community College case was modified by Carpinteria Unified School District and the Mount San Jacinto Community College District decision as recognized in the Sunline Transit District case. So we've got 3 cases that we can see are all we want to look at and how they modified Rancho Santiago before we start relying on Rancho Santiago. So as Ari indicated, we played a little bit with AI in using this hypothetical, and we got a variety of, I think as you said, we got pretty good answers from AI, but not such good explanation about where the answers came from. So it could help you to identify the issue, but it wasn't so good at identifying the cases that we should be looking at when we wanted to make our arguments on it. So the free AI platform's conclusion, we initially entered this acting as if we were an HR director trying to decide whether or not to impose discipline under these circumstances. And the answer we got was, PERB won't automatically sustain the discipline for a heated comment in a grievance meeting. The board is going to focus on whether the steward was engaged in protected activity, and it says that's a grievance meeting almost always is. The speech was reasonable in context and not objectively a threat of physical harm or interference with protected rights.
On that number two, I'm not sure where it's getting reasonable in context, but yeah, the second part of that is right.
Right. And then it kind of summed up with a warning letter based solely on watch your back could well be overturned if PERB finds it was protected union speech lacking a clear threat of harm. If you choose to issue a warning, be sure to document why it was generally unprotected conduct, not just a perceived threat by management. So it's getting at this objective sense as opposed to a subjective feeling of being threatened, because PERB applies an objective standard and gives significant latitude to representational speech. So even when we asked for citations, if we just asked for citations, the free source, the citations we got didn't really support the answer. There were a couple of government code sections that are, generally related, and some cases about California, like a case or two about California public sector labor law that really didn't have anything to do with this particular topic. So that was interesting, and I think AI is pulling from a whole universe of data, and when you ask it for citations, it's not necessarily limiting itself to pulling the data from the citations it identifies. These are appeared to be two separate kind of activities. So we also put it into a more sophisticated, supposedly paid AI-assisted legal research platform, and got kind of a similar conclusion. The union steward's likely to prevail in a claim against the agency if disciplinary action is taken, because the statement appears to fall within the protections afforded to speech during labor disputes. The agency must carefully evaluate the context and nature of the statement before proceeding with disciplinary action. If the statement's determined to be figurative language or bluster rather than a true threat, disciplinary action could violate the steward's statutory rights. And again, with the paid platform as well as the unpaid, it was really important for us to ask for PERB citations. In the paid, when we first ran it and just asked for citations, we only got court cases and statutes and the California Public Sector Labor Relations Practice Guide. But when we specifically asked for PERB citations, we got we got some of the cases that are relevant. So I think the upshot, in terms of using AI, the more specific you can be in your request, the better information you're going to get. And I think, Ari, your point about asking the follow-up questions can be really useful. And again, I want to remind you of our disclaimers about we are not AI experts. We were playing with this. I think all of us are going to be playing with this more and more as we go forward. And the other thing to keep in mind about AI and using it is it's evolving so fast. So anything we say today may not be true tomorrow. So in terms of general guidance for when you're doing your research, I want to make sure that you remember to focus on the facts and don't stop with just sort of a simplistic description of what the legal standard is, because the way you characterize your facts can really make a big difference. And yes, facts are facts, but context matters, and it's important to think about not only how you view your facts and how you're going to characterize your facts, but how the other side is likely to view them and characterize them, and make sure you can see it from a variety of viewpoints. And then read as many decisions as you can. I can't stress how important it is to actually read the decisions, actually read the statutes. Don't just rely on a third party, whether it's a practice guide, whether it's an article by a very smart person. You've got to actually read the cases themselves. And PERB cases are pretty easy to read, and more there's a lot of explanation for you, especially in the recent decisions. So I think the last thing I was going to say, actually I guess I said it all, other than you're responsible for your filings, so PERB's warning about the use of AI is kind of a good warning for all of us. You've got to own what you're doing and take it seriously. And sign up for PERB's emails. Read the cases as they come out. It really helps to just keep abreast of what's happening, even if you don't think the issue is relevant to you today. next month, 2 years down the road, you might say, oh, I remember, I saw that case that came out, and there is law on this.
Great. Well, thank you, Janet. Thank you, Eric. Thank you all for coming. Just close by saying, thank you, Janet. Thank you, Eric. Thank you all for coming. Thank you for reminding me to turn on my mic. I'll just close again by saying, please sign up and come to our monthly events. The next one you can see on the screen is June 24th, and it relates to informal conferences. Also, the bigger events, one was in April, one was today, one is in Glendale in October 8th. However, the one in Berkeley that I mentioned on September 19th is longer, so you need to commit more time to it, or hopefully you can. It takes an entire afternoon and even into the very early part of the evening. We're excited to be hosted for that one by our friends at UC Berkeley, and we hope you can join us.
Yes, thank you very much for joining us. We appreciate your time.
Thank you.